Good afternoon, everyone. Welcome and thank you so much for coming to this panel discussion entitled, What is the History and Possible Futures of Immigration, Deportation, and Refugee Policy? I'm Robert Self. I'm chair of the Department of History, and I'll serve as co-moderator this afternoon with my colleague from American Studies, Monica Martinez. I hope you'll permit me just a few brief framing remarks before I turn things over to Monica to introduce the three speakers. Today's session is part of a year-long series of lectures and discussions sponsored by the Provost, Rick Locke, and President Paxson. And Professor Locke, Provost Locke is with us this afternoon. The series is called Reaffirming University Values, Campus, Dialogue, and Discourse. The next in the sequence is April 17th and will be a lecture and discussion of a lecture about and discussion of Islamophobia by Brown Religious Studies professor Nancy Kalick. When Provost Locke announced this series in the fall, he wrote that its purpose was, and here I'll quote from his letter, to consider how to cultivate an environment in which we as a community can discuss conflicting values and controversial issues in constructive and engaging ways. Affirming the values and methodologies of the university is more than ever critical in an era when the university itself, and here I don't mean necessarily Brown, though that, but rather the university as a space, as an institution, even as an idea, when the university itself finds itself under assault along multiple axes in contemporary political discourse, whether assaults on the validity of scientific research, as we heard last week, or on the production of humanistic knowledge, or, to be frank, on its very students, staff, faculty, and others. One of the essential methodologies of the university is historical contextualization. This afternoon's panel of distinguished historians will help us to understand and think through the discourses and policies of immigration, deportation, and refugees of this last presidential campaign and the new Trump administration within a longer national and global history. As Paul Kramer recently argued in an essay in the Chronicle of Higher Education, too often we reduce history to a desire for, quote, lessons from the past. That's surely one way to think about history and to value it. But my preference is to be mindful that everything is already the past, literally everything up to this moment. Thus, history is a way of uncovering and exploring the fundamentally relational quality of past, present, and future. So here's how the session will proceed. Professor Martinez will introduce our three scholars who will each speak for 15 minutes, and then we'll open the floor to a broader set of questions and discussion with the audience. I want to remind everyone both here and in external rooms that this is being simulcast and it's also being recorded. So I want you to know that before you make comments, just for your information. So thank you to the Provost and the President for sponsoring this series, and thank you so much for coming, both those in this room and those in the overflow. I'd like to turn things over now to Monica Martinez, Stanley J. Bernstein, Assistant Professor of American Studies and Assistant Professor of Ethnic Studies, to introduce the panel. Thanks.
Hello, everybody, and good afternoon. Thank you for joining us. We're thrilled that this room is full, that the rooms where this is being simulcasted are also full. And so I just tweeted the link if you want to watch live from home. We welcome you as well. I'm going to keep the introduction short because you have these beautiful pamphlets with the longer bios of our speakers. But I'm so thrilled to be a part of the conversation, and my own work on violent border policing has built really on the contributions of our panelists today. And for the students in the room, these names are very familiar because they're all reading their work as well. Ngai will begin her comments for the afternoon. She is the Professor of History and Lung Family Professor of Asian American Studies. Ngai is a U.S. legal and political historian interested in questions of immigration, citizenship, and nationalism. She is author of the award-winning Impossible Subjects, Illegal Aliens and the Making of Modern America, and The Lucky Ones, One Family and the Extraordinary Invention of Chinese America. Ngai has written for The Washington Post, The New York Times, The Los Angeles Times, The Nation, and The Boston Review, and most recently for CNN. Before becoming a historian, she was a labor union organizer and educator in New York City. She's now working on Yellow and Gold, the Chinese mining diaspora from 1848 to 1908. Adam Goodman is going to come and give his comments second, and he is an assistant professor of history and Latin American and Latino studies at the University of Illinois at Chicago. His research and teaching interests include recent U.S., Mexican, and Central American history, migration history and policy, and Mexican American and Latinx history. He's currently writing a book that examines the history of deportation from the United States, and the field of history is really anxious for that to be available. He's also published articles, essays, and reviews in academic venues like the Journal of American Ethnic History and popular outlets such as The Nation and The Washington Post. His research has been funded by the National Endowment for the Humanities, the Fulbright Program, the Miller Center, and the Immigration and Ethnic History Society, among others. And finally, Maria Cristina Garcia is the Howard Newman Professor of American Studies at Cornell University. This year, she is also the 2016 Andrew Carnegie Fellow, and she studies refugees, immigrants, and exiles. Her first book, Havana, USA, examined the migration of Cubans to the United States after the Castro Revolution. Her second book, Seeking Refuge, Central American Migration to Mexico, the United States, and Canada, studies individuals and organizations that responded to the Central American refugee crisis of the 1980s and 1990s, and how they helped to shape refugee policies throughout North America. Her third book, Refuge in Post-Cold War America, is a study of U.S. refugee policy in the post-Cold War and post-9/11 era, which will be published later this year. And she's busy at work on her fourth book that looks at climate refugees. So please help me welcome our distinguished panelists, and we look forward to your questions that follow.
Okay, good afternoon. Thank you, Professor Self, Professor Martinez, Provost Locke, all of you for coming out today. It's a pleasure to see you. It's been a very depressing month, but yesterday in particular, I found very upsetting with the news of the implementation memos. So it's good to be with a lot of people to talk about these things as one way to address our feelings about it. I'm going to talk to you about immigration exclusion, the history of that, and the so-called Muslim ban. What I want to do is talk about, I'll talk a little bit about the order, what it covers. It's been under a stay, all right, so we expect actually another order to come out this week, and I'll talk a little bit about that later. But I want to talk about some of its main features and its premises, and then talk about how those premises actually have deep historical roots. So the justification for the Muslim ban, as I'm sure you all know, is national security. And this has been the point of contention in much of the legal cases, because the question is, when the president issues an order based on national security, how far can this court scrutinize the basis of that decision? And that has a long tradition in this country. But if you'll just see, this is some of the language from the executive order. Numerous foreign-born individuals have been convicted or implicated in terrorism-related activities, including people coming on student, visitor, or employment visas, or came as refugees. Terrorists will use any means possible to enter the United States. The United States must be vigilant in the issuance of visas, etc. Now, under this order, it banned for 90 days, or suspended for 90 days, all immigrants and non-immigrants meaning tourists, business people, students, etc., from 7 countries, right? You've all read about this. It also suspended all refugee admissions for 120 days, and it suspended indefinitely all refugees from Syria. Now, the word is that in the new order, they will eliminate the Syrian indefinite suspension of Syrians. Not banned would be religious minorities in countries of nationality, which is a reference to Christians in these countries. And that may not make it into the new ban, but I'll talk a little bit about those things later. Now, the authority for this, the National Security Authority, is in the immigration law, Section 212F, which has been bandied around the media a lot. It says that whenever the president finds that the entry of any aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation and for such period as he shall deem necessary suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose restrictions that he may deem appropriate. That's a very blanket statement of his authority, okay? And this is where I think the litigation right now is very interesting, because this is basically the government's defense for the ban. Now, we have a whole history of exclusions, and that comes to a similar logic. The logic that you see in the Muslim ban, in the authority and the immigration statute, and the logic of national security has a long history in this country. But it was not always the logic of immigration regulation. Before the Civil War, there was no federal regulation of immigration. There was very light state regulations, but there was no federal regulation. And the reason is because when we still had slavery, there was a big difference between the slave-owning states and the non-slave-owning states over who got to regulate the movement of persons, right, or slaves, right? Slave owners didn't want the federal government dictating the mobility of their property, their human chattels. So there was no federal regulation of immigration until 1875. And when the Congress, or when the Supreme Court ruled that immigration was a matter of federal regulation, it ruled it under the Commerce Clause, okay? The idea that immigrants are articles of commerce, right? And the Commerce Clause, because it's interstate, right, is what gives it federal authority. Now, that has a certain logic to it, right, as immigrants are units of labor, right, in one way of thinking, they could be seen as articles of commerce. But in 1889, after the Chinese exclusion laws were passed and challenged in the courts shifted the foundation of immigration policy from commerce to one of national security, okay? And that's because it had to justify why exclude the Chinese, right, which is a patently racist, racially based policy. So in the controlling case, and this still stands, right, in 1889 case, the court said, and you can read this, I won't read the whole thing, but basically that immigrants are potential agents of foreign aggression, right? That foreign aggression and encroachment could come either from a foreign state or from vast hordes of its people crowding in upon us. And if the United States Congress considers the presence of these foreigners of a different race who will not assimilate with us, that's their judgment, right, will not assimilate with us, to be dangerous to its peace and security, their exclusion is not to be stayed because at the time there are no actual hostilities. Actually, now we are in a so-called war on terror, so they actually believe we are in a war, okay? So this basically sees, we usually think of immigrants as economic actors, right? People who move to improve their economic condition and look for new opportunities. Or we see them as refugees who are fleeing from persecution or some kind of desperate situation. But this actually frames immigrants as agents of foreign powers, whether active or latent, okay? And this is so because of this reasoning, we have what's called the plenary power. The plenary power doctrine states that immigration is under the authority of Congress, under the absolute authority of Congress. Plenary in this context means absolute. It's under the absolute authority of Congress, and it's in the same basket of other things that Congress is responsible for in the conduct of foreign relations, like declaring war, making treaties. Okay, so immigration is considered jurisprudentially in the same basket with these other items, which are not subject to the Constitution, right? This has nothing to do with constitutional rights. This is the conduct of foreign affairs, okay? And therefore, the Congress has the right to make any rule it wants, and the executive has the power to implement those rules without interference from the courts, or with very limited interference for the courts. So over the years, a lot of the struggle over immigration policy has been, to what extent can courts have any say over how immigrants are treated? The short answer is very little, very, very little. Okay, so this is how we get to the plenary power doctrine and this argument that's going on right now where the Trump administration is saying, I have the authority to ban anybody I want. And in a certain sense, I hate to say this, he does, right? And a lot of the arguments that are being put forward by the challenges in terms of due process, religious discrimination, are good arguments, but they're not slam dunk arguments, right? This is a complicated question, and a lot of the precedents in immigration legal history has to do with this question of the plenary power and the right of the executive to do what it wants without review, right? So we have many examples of this. Chinese exclusion, probably the most notorious, right? But also, there was a barred Asiatic zone that Congress created in 1917 that covered everything from Afghanistan to the Pacific, right? People were excluded from that area. Then there was a concept called exclusion of aliens ineligible to citizenship. That was in order to exclude Japanese, because Japanese were outside of the barred zone. And it was based on Supreme Court rulings that said that Asians racially could not assimilate, right? They were ineligible to be citizens because they could never assimilate. And then even as some of the Asian exclusion laws were repealed during World War II and the post-war period, Congress created an Asia-Pacific Triangle, which limited the number of people who could immigrate to the United States to 2,000 a year from the whole world. Okay, then I'm sure many of you know about the internment of Japanese Americans during World War II, also on national security grounds, which was actually shown in the 1980s to have been based on falsified information given to the court, right, where they covered up investigations by the FBI and the Office of Naval Intelligence that Japanese were not a threat, right? And these cases also have to do with to what extent can the court review a decision based on military necessity, right? So the Korematsu case, which everybody says is a dead letter, and I'm not so sure that the last nail has gone into that coffin, right? That was vacated because of this finding, but the ruling that the court should not review decisions of military necessity, that still stands. And then more recently, after 9/11, you had the National Security NSEERS registration program, under which people entering the country from 25 countries had to register. 24 of them, majority Muslim countries. North Korea was the 25th. 138,000 people had to register on entering the country. 83,000 domestic people who were living in the country before 2001 had to register. Although they deported 13,000 people who registered, no people were ever charged with a terrorist-related crime. So one of the things that Trump likes to talk about is extreme vetting. I'm sure Professor Garcia will talk about this later, because refugees are vetted more heavily than anybody else. But this is also a long practice in the exercise of our exclusion policies, the use of administrative tools and interrogations, or what we now call extreme vetting. This is a picture from Angel Island, the immigration station in San Francisco Bay that was established to interrogate Chinese entering the country to determine if they were who they said they were. And people were detained there days, weeks, months, even in some cases, years. Now, in the executive order, and we'll see if this remains, I think it will when it gets revised, in Trump's executive order, there is a section on implementing uniform screening standards for all immigrant programs to detect fraud and desirability. So they want to develop a program that will include standard procedures such as in-person interviews, and which include a process to evaluate the applicant's likelihood of becoming a positively contributing member of society and their ability to make contributions to the national interest. Now, I would say that's a very subjective determination, right? So it's going to be in the hands of an immigration officer to determine if the person coming before him or her is desirable. Now, when Trump signed this executive order, he, in his own loquacious way, explained that we only want people to come to our country who love deeply America. Now, who love deeply America. Now, first of all, how would you measure that? Second, this is supposed to apply to short-term visas, people who are businessmen or tourists. Do we expect tourists to love deeply America? This is very troubling. And he believes that Islam hates us, right? This is direct quote. And he also said, radical Islam is very hard to define. It's hard to separate because you don't know who's who, right? This is what they said about the Japanese, that you could not tell the sheep from the goats, right? The loyal from the disloyal. So you have it set up, at least from an epistemological point of view, that no Muslim could pass the Love Deeply America test. Okay, so we remains to be seen how this would be implemented, but I can imagine Europeans sailing through their interviews and Muslims failing their interviews. Okay, so what are the consequences of exclusion? Well, historically, and we can see what's happening today. Internationally, it stigmatizes whole populations as enemies of the United States, straining our relations with other countries. It diminishes our reputation. Domestically, it stigmatizes those people who are here, encourages hate and violence, discrimination, et cetera, et cetera. After the exclusion laws were passed against the Chinese, after they were passed, there was a spike in hate crimes, arsons, lynchings, burning down of Chinatown, 200 such incidents up and down the West Coast after the exclusion laws were passed. Because when the law says these people are not wanted, it gives license to people who hate. Okay, let me just wrap up by commenting on what some of the challenges are. I mean, we are now since I think World War II, we have a kind of ethos in this country that we should be inclusive, that we should not discriminate in our immigration policy. But things go up and down, right? Nothing goes in a straight line. And I think popular resistance, all the people that went to JFK and the other airports was very important in terms of the public opinion. There was a big demonstration in New York on Sunday of solidarity with Muslims. But the polls actually tell us the nation is divided. More than a majority oppose the Muslim ban, but close to 45 to 49% support the Muslim ban. Okay, so we live, as we know, in two different universes, it seems sometimes. So this is why I believe the legal challenges and the courts are really important, because one of the things about our system that's important is that the courts are supposed to protect minorities from the tyranny of the majority. And the courts have shown already to be an important bulwark. I don't know if it's going to be enough. I think the challenges are actually very complicated. As I said, the plenary power is very powerful. And Trump is now cleaning up the executive order to avoid some of the obvious difficulties that were in the first one. But he is probably going to exempt green card holders from the ban. But I think he is probably within his authority to say he's going to ban people from these countries and to say he's going to suspend refugees and limit the number. Those are actually within his authority. So we are looking at, I think, a very difficult period ahead, I'm sorry to say. Thank you.
Thank you very much to Provost Locke, to the Office of the Provost, to Professors Self and Martinez for inviting me, for all of you for being here to engage in this important dialogue and discussion. I'm very honored to be a part of it. As Professor Ngai just discussed, and as all of you know well, during his first month in office, President Donald J. Trump has signed a series of controversial executive orders on immigration and deportation. Now, much of the discussion surrounding these orders has centered around whether or not they are constitutional, whether or not the administration is serious about implementing them, and what's going to happen. Many people might be overlooking, however, what the real intention and what the real point is, and that is creating fear in immigrant communities. Announcing the executive orders, releasing the draft memos, regardless of whether or not they are implemented, is part of a larger strategy, a conscious strategy of coercing people into quote-unquote self-deportation. Right? Even if the administration can't or won't actually construct a wall along the entirety of the 2,000-mile U.S.-Mexico border, hire 15,000 new ICE and Border Patrol agents, or deploy 100,000 National Guard troops to carry out deportation raids across the country. They can threaten to do so, and they have, in hopes of pushing people into the shadows and perhaps out of the country altogether. Now, the Trump administration's actions can only be described as an all-out attack on immigrants and immigrant communities. As one advocate described it, is a form of psychological warfare. Now, this, of course, in some sense, is not new. It didn't just start either with the 2012 election, when presidential candidate Mitt Romney touted self-deportation as the centerpiece of his immigration policy. And it's worth remembering that at the time, President Trump referred to that as a crazy plan and maniacal. The federal, state, and local governments and officials have long relied on self-deportation as a critical component of the larger deportation machine that the United States has built over the last 125 years. And I'd like to share a little bit of the genealogy with you today. Self-deportation played a central role in two of the most notorious expulsion campaigns in United States history. During the Great Depression, as many of you know, anti-immigrant sentiment spiked as citizens sought out convenient scapegoats for rising unemployment and economic woes. In response, immigration officers deported tens, if not hundreds of thousands of Mexicans and Mexican Americans. But at least 500,000 people left the country in response to publicity campaigns. Publicity campaigns by immigration officials, by local and state officials as well, in addition to the Mexican government's encouragement of people returning. In 1931, Charles Vissel, who was the head of the Los Angeles Citizens Committee on Coordination of Unemployment Relief, argued that a well-orchestrated drive with all publicity possible and pictures would act as a psychological gesture and would scare many thousand alien deportables into leaving. Those are his words. Walter Carr, who was the Los Angeles District Director of Immigration at the time, agreed. He acknowledged that while the machinery set up for deportation would be entirely inadequate on a large scale, he believed that with a little publicity, a large number of people, actuated by a guilty self-conscience, would move south over the line on their own accord, according to him. 2 decades later, officials doubled down on their use of scare tactics during what was known as Operation Wetback, the infamous deportation drive in 1954 and 1955 that Donald Trump has cited as a model for his own efforts. During this operation, Border Patrol agents were organized into special mobile task forces, and they rounded up and deported up to 200,000 people throughout California and South Texas. There was also an interior campaign that has been largely overlooked, which I'll discuss in a minute. But the operation began well before immigration officers started apprehending anyone. In the weeks leading up to each phase of the drive, the INS, the Immigration and Naturalization Service, launched carefully planned, large-scale publicity campaigns meant to scare people into preemptively returning. Newspapers, radio stations, local and national television stations played a key role in this effort. They provided advanced publicity for the drive, and also they covered it once it was underway. By the middle of the summer, the INS claimed, and I stress claimed, it's hard to get any kind of proof, but they claimed that up to 3 times as many people had left the country in response to the scare tactics as had actually been apprehended. Self-deportation became even more important once Operation Wetback moved to the interior of the country. On July 30th, the Attorney General, Herbert Brownell, announced that Chicago would be the focal point of a federal immigration service drive to return Mexicans. Yet local officials refused to provide details about the operation or even corroborate its existence. Right? They were hoping that the rumors would spread. It would scare people into leaving, regardless of whether or not it materialized. A press release from the Chicago District Director made this clear. It said, "Without confirming or denying the possibility of any drive, I should like to offer advice to all aliens illegally in the United States. Obviously, the simplest way to avoid formal deportation is for the individual to depart from the United States on his own accord." Media coverage and the assistance of the American Civil Liberties Union and other local organizations that might have had in mind the rights of the migrants themselves, but in turn helped to publicize the drives. Right? We're seeing this happening today as well. Right? This generated anxiety, understandably, in the Mexican community. Organizations like the Hull House in Chicago and the Mexican American Council of Chicago reported that the wives of undocumented people began seeking out advice in large numbers as to how their loved ones could regularize their status. A few weeks into the operation, officials again reported that more people had left in response to the publicity campaign than had actually been apprehended. Now, I should also note that many people did not leave. Right? Many people refused to leave. Right? Many Mexicans in Chicago were established members of the community, right? Rather than recent arrivals or seasonal labor migrants. By the time of Operation Wetback, some people had lived in the city for 30 or 40 years. The INS realized that the community's deep roots presented challenges to their campaign. Right? As the district director at the time noted, or perhaps lamented, many have purchased household furnishings, automobiles, appliances, and clothing on extended payments, have established bank accounts, postal savings accounts, public utility contracts, and in short, become involved in all the complexities of the average city dweller. They have gained employment with large corporations, making difficult the arranging of expeditious payment of wages due. In addition, and perhaps more important from our standpoint, They have acquired associations with citizens and resident aliens, which results in demands for release on bond, representation by counsel, and in many cases, applications for discretionary relief. By the 1950s, many Mexicans in Chicago had become American for all intents and purposes, even if not by citizenship. In the 1970s and 80s, a spike in undocumented immigration and the INS's inability to control it led the agency to carry out an increasing number of workplace and neighborhood raids in ethnic Mexican communities. During this period, the fear of being apprehended and deported became prevalent, especially among long-term residents. And the interaction, or the possibility of an interaction with an immigration officer, became a part of many undocumented people's lives. In some cases, it circumscribed the physical space they inhabited. Some Mexican towns and Mexican parts of Los Angeles, for example, were described as ghost towns. And as one other undocumented person put it, being here is like a prison, a beautiful golden prison. You have everything, but at the same time, you have nothing. And this point was driven home to me when I was doing some oral history work in the central western Mexican state of Jalisco a few years ago. And I spoke with a couple, Maria and Alvaro, who had spent decades in the United States and had gone on to become citizens. And they described the raids upon first arriving to Southern California in the early 1980s, right? And described the ways in which it limited them, right? They stopped going to Sunday Mass because there were raids at the churches. They stopped going to the movie theater. They stopped going to the store. This was a very real fear. And it's also worth mentioning that this did not just affect undocumented people. And it affected all Latinos regardless of citizenship. You have no idea, unless you have brown skin, of how unsettling these raids can be, a US-born California Senate aide stated in the late 1970s. It isn't a matter of the numbers of officers involved. It's the whole idea, he said. You only need to have one man in a green INS uniform walk through the Mercado, and a shiver of fear runs through all of East Los Angeles. Over the course of the last two decades, important difference, last 2 decades, self-deportation efforts have only grown, fueled in part by prominent raids, like that in Postville, Iowa in 2008, and also the proliferation of restrictive federal, state, and local immigration laws. Right? These have been driven in part by anti-immigrant restrictionists and organizations like the Center for Immigration Studies. Right? They see self-deportation as a third way, is what they call it, a third way between legalization and mass deportation. Now, one of self-deportation's leading proponents is Chris Kobach, who's pictured here, or the Secretary of State of Kansas and someone who was integrally involved in drafting restrictive immigration legislation at the state level, like SB 1070 in Arizona. He later went on to serve as advisor to Mitt Romney and most recently as advisor to Donald Trump. It's not difficult to connect the dots. But as he put it in a law review article in 2008, he wrote, "The 12 to 20 million illegal aliens in the United States need not be rounded up and forcibly removed through direct government action. Illegal aliens can be encouraged to depart the United States on their own through a concerted strategy of what is called attrition through enforcement. If the risks of detention or involuntary removal go up and the probability of being able to obtain unauthorized employment goes down, then at some point the only rational decision is to return home. But rather than returning people to their homes, proponents of self-deportation are tearing people from them with devastating consequences." Now, history teaches us that the deportation machine that has been constructed over the last 125 years is anything but invincible. It was vulnerable in the past, it remains vulnerable today. Right? And I think anyone who wants to fight against deportation must first understand how the machine works, understand its different components. And today, that means recognizing the important role that anti-immigrant fear campaigns have played throughout history and the ways that authorities have strategically used the media to propagate them. This in turn enables us to understand a little bit better, perhaps, the Trump administration's recent actions, like the apprehension of the young man with DACA status in Seattle, the deportation of a domestic violence victim in Arizona, the highly publicized raids 10 days ago that resulted in the apprehension of over 600 people. Right? While it's true that these enforcement actions targeted specific people, we must also recognize who else they were meant for. Right? The 11 million other undocumented immigrants in the country and the tens of millions of people, including many in this room, no doubt, who are connected to them. Right? Levels of fear are high, to be sure, but people are also, as you well know and as you see here, taking to the streets and the courts in numbers that this country has not seen in decades. And they're organizing and marching and doing all within their power to defend themselves, their families, and their communities. Right? These developments are encouraging, but we shouldn't consider them necessarily to be sufficient. Right? In the days, weeks, months, and years ahead, I think all people of conscience will need to wake up and step up. What can each of you do to make a difference here on campus, in Providence, and beyond, perhaps? Right? These are the pressing questions that we all must ask ourselves and do our best to answer. In doing so, we will not only reaffirm our personal convictions, university values, but perhaps over time, our unfulfilled aspiration to be a nation that welcomes and embraces immigrants. Thank you.
Thank you. It's an honor to be here with you this afternoon. This afternoon, I'm going to try to put Trump's executive order on refugees in some type of historical perspective. Now, the term refugee has been used freely by clergymen, by journalists, by humanitarian activists to refer to a wide range of people who have been of humanitarian concern. Over the course of U.S. history, the term refugee has been used to refer to a wide range of people. The term has been used to refer to the people who fled the failed German Revolution of 1848, for example. The term has been used to refer to those who were displaced by the Civil War. In 1865, for example, the federal government created the Bureau of Freedmen and Refugees to provide federal aid to a very large population. The term refugee has been used to refer to the Mexican Chinese that General John Blackjack Pershing brought back with him after the failed expeditionary force to Mexico to capture Pancho Villa. Pershing had to receive special permission from the federal government in order to bring in these Chinese because the 1882 Chinese Exclusion Act had barred the admission of all Chinese immigrants, as Professor Ngai pointed out. And more recently, the term refugee has been used to refer to the tens of thousands of Gulf Coast residents who were displaced by Hurricane Katrina in 2004. But the term refugee has a very precise legal meaning, and that legal meaning was crafted after the Second World War. And because of that legal meaning, the number of people who are eligible for refugee status, for refugee resettlement in the United States, is actually quite small. So let's talk a little bit about that history, how our definition of refugee emerged and who has been prioritized for admission to the United States. The first attempts to craft a coherent refugee policy, or rather a separate track for refugee admissions, occurred in the wake of the Second World War. Between 1948 and 1956, roughly 600,000 people were admitted to the United States through the Displaced Persons Act and the Refugee Relief Act. Displaced persons and refugees were defined at this time as victims of Nazism and those who could not return to their homelands because of some type of persecution. Congress passed this legislation to assist Europe in its post-war recovery by accommodating a share of those who had been left homeless and in some cases stateless by the war. The majority of those who were admitted under these two pieces of legislation came from Southern and Eastern Europe, and most of them would not have been admitted to the United States otherwise because of the racist national origins quotas that had been in place since the Johnson-Reed Act of 1924. Over the next 2 decades, U.S. policies signaled a growing recognition that the United States, as a member of the international community, had a responsibility to assist displaced persons around the world. The 1952 Immigration and Nationality Act, for example, granted the executive branch the parole authority to admit people to the United States, to physically enter and remain in the United States outside of immigration quotas if it was deemed in the national interest. The press referred to these people as refugees, but their technical status was parolee. For them to become permanent residents and citizens of the United States, Congress then had to pass a series of adjustment acts to normalize their legal status. Perhaps the most famous of these adjustment acts is the Cuban Adjustment Act of 1966. Through this parole authority, the executive branch authorized the admission of tens of thousands of people displaced by the new post-war communist governments in Eastern Europe, but also in other parts of the world. Then, a decade later, in 1965, when Congress passed the Hart-Celler Act to abolish the racist national origins quotas in immigration law, it included within the global ceiling of admissions a small, actually tiny quota for refugees, roughly about 6,000. The Hart-Celler Act defined refugees at this time as those persecuted on account of race, religion, or political opinion, those who had been displaced by natural calamity, which I find interesting, those who were fleeing communist or communist-dominated countries, and those fleeing the Middle East. But when the quota proved to be insufficient, the executive branch continued to parole people into the United States in the tens of thousands. Now, over time, members of Congress became increasingly concerned that by this overuse of the parole authority, which they said was providing a backdoor to the United States. And these concerns eventually led to passage of the 1980 Refugee Act, which established a permanent track for refugee admissions, but one that required congressional consultation. The 1980 Refugee Act drew on the UN definition of refugee and defined a refugee as a person outside of his country of nationality or habitual residence who could not return because of a well-founded fear of persecution on account of race, religion, nationality, membership in a social group, or political opinion. The 1980 Refugee Act also established guidelines for granting asylum for those who petition for protection from the United States at a U.S. port of entry, say the U.S.-Canada or U.S.-Mexico border, JFK, Logan Airport, at these ports of entry. So the 1980 Refugee Act requires an applicant for refugee status to prove that they have a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. But you also have to prove that you are who you say you are. You have to prove your identity. You have to prove that you have no criminal record. You have to be a civilian. So if you were a member of a paramilitary force or a member of the military or even a member of the police, you would not be considered a refugee. You do not qualify for refugee status. You have to have crossed an international border. In some cases, the U.S. government has allowed some refugees to apply for refugee status within their country of origin. But for the most part, you have to have crossed an international border. You have to demonstrate that you have a reasonable fear of future persecution, that it's not just a one-time event, but that there's a reasonable fear of future persecution in perpetuity. And you also have to demonstrate that your state failed to protect you, that you could not have been safe, for example, by moving to another part of your country. You have to demonstrate that the state failed to protect you. So since 1980, the White House, in consultation with Congress, sets a limit every single year on the number of refugees that will be admitted from every region, from different regions of the world. And here is what Obama's presidential determination for 2017 looked like. This is what refugee admissions for 2017 would have looked like if not for Trump's executive order, where he slashed the refugee admissions by more than half to 50,000 and then barred Syrians altogether. Now, as Professor Ngai pointed out, he has reversed on the exclusion of Syrians, but who knows what may happen next week. During the Cold War, anti-communism was the lens through which we interpreted who was worthy of admission to the United States as a refugee. And the majority of our refugees came from just 3 countries, the Soviet Union, Vietnam, and Cuba. Since the end of the Cold War, the war on terror has become the new lens through which we interpret who was worthy of admission to the United States as a refugee. And as Trump's executive order shows, there's a great fear of accepting refugees from certain parts of the world. The post-Cold War era has also presented yet another challenge to federal authorities. What do you do with the growing number of people who are asking for asylum at a U.S. port of entry? During the Cold War, asylum cases were relatively few, and the cases that attracted the most media attention were the defections of high-profile celebrities, individuals, people like Russian ballet dancers like Alexander Godunov, or Cuban baseball players like El Duque Hernandez, or Cuban jazz musicians like Paquito de Rivera, or Eastern European coaches like Bella and Marta Caroli, or athletes like Olga Komanichi and Martina Navratilova. Asylum seekers were generally released on their own recognizance while they awaited for an administrative determination or a hearing in an immigration court. But since the 1980s, petitions for asylum have skyrocketed, backlogging the immigration courts. In order to discourage people from seeking asylum on U.S. soil, the federal government has adopted a series of policies, including expedited removal, the denial of work authorization, and the indefinite detention in an immigration prison to discourage people from seeking asylum, because the position of the federal government is that most of these asylum cases are frivolous and that they are contributing to the backlog of the immigration courts. And so these policies have to discourage everyone except the bona fide asylum seekers. And we can talk more about these policies during the Q&A if that is of interest or of concern to you. Since 1993, the year of the first World Trade Center bombing, Americans have increasingly demanded that their policymakers be more proactive in screening refugees and asylum seekers in the interest of national security. Are these demands reasonable? Well, you as engaged citizens have to decide for yourself. But as you make this decision or try to reach this decision for yourself, let me share with you some information. According to the Cato Institute, a libertarian think tank in Washington, D.C., during a 40-year period between 1975 and 2015, the United States admitted 3,252,493 refugees. During that 40-year period, 20 of those refugees attempted to carry out a terrorist attack or succeeded in doing so inside of the United States. 3 Americans were killed during these attempts. All 3 murders occurred in the 1970s, and they were committed at the hands of Cuban refugees, not Muslim refugees. The author of the study admitted that each one of these murders was a tragedy, and I think we can all agree with that. They were tragedies. But the author of the study calculated that our risk of being killed by a refugee terrorist was 1 in 3.6 billion per year. By comparison, our chances of being killed in a motor vehicle accident are 1 in 133. Of the 700,000 asylum seekers admitted to the United States during that 40-year period between 1975 and 2015, 4 tried to commit acts of terror. All 4 of these acts either occurred either before 9/11 or by people who came to the United States as babies or toddlers and became radicalized on U.S. soil. And according to the author of this study, the chances of being murdered in a terrorist attack committed by an asylum seeker was 1 in 2.73 billion per year. Today, of all the people who travel to the United States in a given year, refugees are the most vetted population. The typical refugee, and this chart gives you a sense of all the different hoops that you have to jump through in order to receive that coveted refugee visa. The typical refugee takes 18 to 24 months to screen. Americans are under the mistaken impression that if refugees wait long enough, they will eventually be admitted to the United States, and that's simply not true. Today, there are over 60 million refugees and displaced persons worldwide. If an applicant for refugee status cannot prove his identity, or if there is anything questionable about their background, they are not selected by the Department of Homeland Security. Applicants have been turned down for fairly innocuous activities like bouncing a check or even for being a victim of a crime, not a perpetrator, but a victim of a crime. If there's something a DHS official doesn't like about a particular applicant, if it's just a gut feeling that there's something wrong about this application or they just can't put their finger on it, chances are that person is rejected. And with more than 60 million people to choose from, they don't lose much sleep over it. They can very easily fill our immigration quota and then some. Today, the real burden of accommodating refugee populations is borne by the countries that border areas of crisis. As generous as U.S. policy has been, and the U.S. has consistently been on the list of the 10 most generous countries in terms of accommodating refugees and asylum seekers. As generous as our policy has been, and I can speak to that generosity because I myself am a refugee, the real burden of accommodating refugees is borne by the countries that border areas of crisis. It's countries like Jordan and Lebanon and Tanzania. Some refugee camps like this one in Jordan, al-Zatari, are larger in population size than some U.S. cities, towns and cities. In September of 2015, President Obama raised the quota, the refugee quota, from 70,000 to 85,000 for fiscal year 2016, and pledged to admit 10,000 Syrian refugees within this quota. You might be interested to know that 2016 was the first time since 9/11 that we have actually met our quota. Most years, our refugee quota is not filled. Earlier, I showed you the presidential determination for fiscal year 2017 that would have raised the quota to 110,000. But Trump's January 27th executive order reduced the refugee quota by more than half to 50,000. He also imposed a 120-day suspension on all refugee admissions, and it imposed a travel ban on refugees, immigrants, and travelers from 7 countries. As we all know in this room, a lower court and the Ninth Circuit Court of Appeals blocked the travel ban, but the limits on refugee admissions remain. They were not challenged in the courts, and they remain in place. So to conclude, when you look over the course of refugee history, or the history of refugee policy in the United States, you see how most administrations have used either the refugee system, the parole system, or the asylum system to facilitate the entry of people who were of humanitarian concern. We have now entered a period where our administration is using the refugee parole and asylum system to block people from coming in. And that is a radical departure in the history of refugee policy. Thank you for your attention, and I welcome your comments and questions.
Okay. All right. Thank you, everybody. Thank you again to our panelists. We are going to go ahead and open the floor for questions. So please, we'll have 2 helpers with microphones.
Mics.
And we'll also remind you that this is being recorded. So keep that in mind. Yes, question over here in the back.
Can you hear this? Can you guys, does this, yeah. I was wondering, what was the legal basis for indefinite detention, specifically of Central American immigrants or people applying for asylum? Is there a law against that? Is that like just a pore in the legal system? Or is it in violation of any laws?
The practice of indefinite detention began after the first World Trade Center bombing. In the wake of the first World Trade Center bombing in 1993, Congress passed the 1996 Immigration Act, the Legal Immigration Reform and Immigrant Responsibility Act. And that it created a whole series of policies to try to make Americans feel safer about populations that were coming into the United States or who might already be physically present in the United States. And this whole discourse began that people who wish to cause harm to Americans were using or abusing the immigration system and the refugee and asylum system. So a whole series of policies were created in the wake of that first World Trade Center bombing. And so this became the policy to indefinitely to detain indefinitely asylum seekers became a practice after 1996. It was considered that it was preferable to err on the side of caution to protect Americans than to abuse perhaps the civil liberties of people who were being detained. People who were working for the INS and then later on what became the Department of Homeland Security had to weigh. They had to decide what was the better option, and they decided that it was best to protect Americans, even if it meant keeping people indefinitely in an immigration prison. Now, on occasion, exceptions will be made. So if an asylum seeker has a family network here in the United States that is willing to vouch for him or her, then and if they don't have anything in their background that suggests that they might commit a crime on U.S. soil, then they might be released to their family members. But in most cases, I think authorities are prefer to err on the side of caution and detain people indefinitely. Thanks for the question.
We have two up here in the front. Three, actually.
Hi, thank you so much for being here. This was really wonderful. So I have two questions. One in particular was after Professor Goodman, your 15 minutes, I guess. And the other one, I am very curious to sort of have the panel answer. So the first one is, so you mentioned that part of the real intention is to create this fear for immigrant groups. And I believe that 100%. However, my question is it just immigrant groups? I think that the creation of fear might be happening for a lot more other groups, and in particular, the work that fear does for the white majority. And those are actually not, obviously not mutually exclusive, but I wondered if you can say how fear works, not only for minority and marginalized groups, right, but for others as well. And then my second question, which I'll just say now, that way I don't have to get the mic back. Let's see. So I also think one of the things that not only you mentioned, but I've been reading as well, is about this idea of going back to our American values, our nation, quote unquote, of immigrants, right? And I've been really going back and forth in terms of thinking about that, because I wonder, when were we ever that? Have we ever been a country that has welcomed everybody at any particular point? And is it just a myth? Is it just this mythical period that we in fact use as a symbol so that we can think that we can go back to this time period that I quite can't remember? Yeah, those are my two questions. Thank you.
Yeah, thank you for those questions, both excellent. I mean, very quickly on the first one, I agree 100%. I don't think the fear is meant or intended just for immigrants or undocumented immigrants. As I mentioned toward the end, there are tens of millions of people who are connected to them, but also, others who the fear, as you pointed out, might function to advocate for or support, more draconian immigration policies. And I think, Professor Ngai mentioned that, on the question of the ban of immigrants from the 7 countries, there's a fairly even split, a slight majority who are against it. But I think, certainly fear plays a large part in shaping people's opinions and also, generating support for policies that might be restrictive. In terms of the nation of immigrants question, I think you're 100% right. I didn't mean to imply that. I guess what I prefaced that with at the end was the unfulfilled aspiration to be a nation that has welcomed and embraced immigrants throughout its history. People on this panel have written about this extensively, certainly more than I, and others have discussed the long history of the United States as a nation by design. That there have always been, some people who have been welcomed and others not, and to think otherwise or to think that we're in a completely new era, I think would be misleading.
The idea of America as a nation of immigrants actually is a fairly recent idea. It was an idea that emerged in the 1950s, after World War II, among European ethnic groups that were looking for immigration reform. And they narrated their own success story of assimilation as a way to claim a past that would secure their own futures, right? So retrospectively, America was then narrated as a nation of immigrants, which at one level I think is false. The idea that the people who came to the 13 colonies were immigrants is wrong. They were settlers. They were colonial settlers, right? And they displaced indigenous people. So, or people who came from African chains were not immigrants, right? So if you say that everybody who came here was an immigrant, you efface important parts of our history, right? So this was a very powerful narrative because it propelled a whole generation of people that were the children and grandchildren of the immigrants who came at the turn of the 20th century to make their claim in American society. And the reason why they could say they succeeded was less so because they were hardworking immigrants, although they were hardworking, I don't deny that, but more because after World War II, you had an expanding economy, you had a strong welfare state, you had a declining income inequality, you had many social and economic structures that enabled people to move up in their occupational positions, whereas we have much less of that in the last generation. On the other hand, I think a nation of immigrants does have a positive and powerful utility because immigrants embrace it themselves to make their claim to be part of this society. So I don't think it's wrong that immigrants today say we are a nation of immigrants because what they're saying is that we're also part of this nation. But it doesn't bear really close scrutiny as a historical fact. I think it's more like Adam was saying, it's an aspiration.
Thank you very much.
Maria, do you want to?
No. It's all right. Actually, I think let's end on that note.
Okay.
Let's hear the questions. Thanks.
Thank you very much for all of your presentations. I have a question for Professor Ngai about the Muslim ban and kind of the role of the courts. So you mentioned the plenary power. It's very strong established doctrine. And I guess my question is related to what is the role of community activists and organizations? If a lot of the politics is going to shift to the courts, how do we remain and keep communities engaged and invested? Because I think, with the airport protests and those types of things, it was really powerful to see that. And I have a question for Professor Goodman in terms of kind of the ways in which we react to and think about the deportation machine. I think you made a very compelling argument. And I guess I wonder about the kind of undocumented youth activists saying #HereToStay, saying I'm going to kind of call them out and say, if you want to come and attack our communities, like, we're going to actively resist and push back. And also Chris Kobach, right? So Arizona and SB 1070 and the way in which it kind of led beyond undocumented people, but criminalizing harboring of undocumented people, being related to an undocumented person. So kind of what do you think that the potential impact would be for citizens, permanent residents, kind of following up on the previous question?
So that's a great question. I think there's a really important relationship between mass protest and activism and resistance and what the courts and what Congress will decide. There's definitely a connection. The courts do not exist in a vacuum. The courts pronounce this policy, the plenary power and national security, because it was the hated Chinese, and very few people stood up for the Chinese in the 19th century. Some missionaries were really the only ones who stood up for the Chinese. The Japanese-American internment happened when there was virtually no opposition to that action among the American people. Even the Northern California ACLU, who objected to it, was reprimanded by the national ACLU for going against national interest. So I think there were some Quakers and a few other people who opposed the internment. That was also hard because there were Japanese Americans themselves who supported it. That's another story, right? They were trying to prove their Americanness. So that's another lesson, right? If we don't stand up for ourselves, other people won't stand up alongside us, okay? So a lot of these really, these extreme powers that the executive has in immigration matters grow out of these periods of racial discrimination and oppression where there was very little support for those communities. I think today you have a very different situation where there's mass protests. It's not the whole population, but it's significant. And I mean, it's interesting that these judges, I mean, their actual rulings don't bear super close scrutiny, but they, and legally, they're mostly dealing with legal permanent residents, right, and people who had already been visaed, right? So there are, I think you can make due process claims in terms of if somebody is already a green card holder, already has a visa that's been issued and then is blocked from coming in, right? But they did not rule on the refugees, right? And aliens who have never been in the United States, right? People who are foreigners who have never been in the United States and who are not in the United States do not have a right to enter. That is very clear in our law. Now, that to say everybody should have a right to enter regardless of where they are, that's a position, right? That's a very, I won't say extreme, but that is a position of a no borders kind of position. But I think most Americans would not agree with that. Most Americans would say, well, you have to have some policies, right? You can argue over how many and on what basis, right? But aliens who have never been in the country and have not been admitted do not have a standing right to enter or to sue to be entered, right? So there's a certain line that is not really going to be dealt with by the courts. But the courts, I think, are really, the reason for these rulings, I think, in a large measure is because of the mass opposition. Because they could have ruled the other way. They could have said, it's in the 212F, national security, and he can do what he wants. I mean, that would not have been a surprise. It was actually more of a surprise that the ban was stayed. So anyway, so I think the mass protest is absolutely crucial. And no major court decisions, especially those who have overturned longstanding precedents of discrimination, none have ever been made without a mass movement out there. Gay marriage, Jim Crow segregation, Brown v. Brown v. Board of Ed, right? They were all connected in their times to mass movements.
I was just going to say, could you just say a little bit, given that analysis, and given the plenary power and 212F, I mean, do you have any prognosis for once it's revisited by the courts? Do you think that it's likely? I mean, what protests, leave sort of protests aside for
Well,
a
I
second,
think
what's your
it's-
legal sense?
Well, not being a lawyer and not being a predictor of the future, as we historians always use that cop-out. Well, it's moot, actually, because Trump is going to he's redoing the order. So I think they've determined that he will probably lose, especially with regards to already visaed persons and green card holders. So they're going to make it clear that they're exempt. And I believe they're going to eliminate the indefinite suspension of Syrian refugees. You know, and but he can lower it to 50,000. And I read yesterday that the 50,000 is actually almost met. So there's only 15,000 slots left for the year. So it's going to be really hard for anybody to get in through that window. So I think that they're going to clean up the executive order so that it will withstand judicial scrutiny.
Sorry, I was just going to briefly respond. Thank you for your question, Kevin. And I know that your own work has, done a great job, I think, of showing the importance of activism by young undocumented people. I agree wholeheartedly with, what May said about the importance of activism and social movements and public pressure. It, in some cases, can shape, perhaps, policy or judicial decisions. In other cases, perhaps not. But I think it's an essential ingredient, as she mentioned. I think the other thing is that I tried to bring out a little bit is that, deportation practice, the mechanisms of deportation, policy has changed over time, and activism in response to that has also changed over time. I think we're seeing that, certainly now, but it's important to recognize that it might not take the same forms in the past, although there might be some continuity. Symbolically, I think it's incredibly important that so many institutions across the country, dozens of institutions, have declared themselves sanctuary campuses and sanctuary cities across the country. That's very important symbolically. I also think it's really important to go the step further, as some places have, and start getting really concrete about what that means. And I think that many places are doing that now. Putting in place action plans, know your rights workshops and campaigns. And I think those steps are really essential and crucial at this particular moment of time, given what we've seen in the executive orders, as well as some of the draft memos that might or might not come to pass.
If I might just say, refugee policy is very responsive to advocacy. I mean, that's the one area of immigration policy where you see that advocacy plays a major role. So, especially since the end of the Cold War, why did we admit so many, for example, Jewish refuseniks from the Soviet Union? In the late 90s, finally, more and more Haitians were admitted after many decades of being excluded. The Cubans are the classic example. I mean, all of these populations were brought into in fairly large numbers because of advocacy, because they had powerful interests or representatives in Congress or advocacy groups that were willing to lobby on their behalf.
I think that that's also just an important reminder that fear can inspire collaboration, and that for vulnerable communities, one example is in the wake of Japanese American internment, that you had Mexican Americans coming forward and saying that they had memories of this, and they spoke out in solidarity. And I think that echoes today when you see collaborations and coalitions being formed across religious groups, but also in response to policing, right? So the seeing raids today makes multiple populations feel vulnerable, not just immigrants, but bodies that are used to policing and being targets of policing. And so I think that fear can inspire collaboration and protest in really important ways, and it's needed now more than ever. So I think now, because there were so many hands in the air, I think what we're going to do is actually take a collection of questions so that the panelists can respond collectively. So we had one student in the back over here, Danielle, and then one over here, and we'll get two questions in the front.
Hi, thank you again so much. I was wondering, and I know you said, and historians always say this, that they can't predict the future, but thinking about how long-lasting and how deep will these effects be if these policies are enacted, especially through Congress? And can you speak a little bit about that? And then also talking about historically, is this on? Historically tying immigration and economics. Is that rhetoric dangerous, or is it an effective strategy because that's how people get in? And what are your thoughts about that?
Oh, and then I just, okay. Yeah, my question was specifically about refugee history, which I think like within a Cold War analysis has been dominated by this sort of like deceptive benevolence or like I guess like liberal humanitarianism, where like you will like let people, like the United States will let people in, but also be like indirectly or directly responsible for displacement, and using like refuge and immigration as ways to sort of like conceal or redeem that violence. And I was wondering, in this like contemporary like moment within this administration, do you feel like we've sort of left that whole like, I guess like more nuanced like benevolence behind for like outright nativism and exclusion at this point? And what future do you see for refugee policies within and beyond this administration?
And then we're a couple, do we get a couple up
Two
here
more.
and then we'll,
And actually, there was a hand over here, so we'll get to you. So one of the students here and over here.
Yes, just to take one of the former questions one step further, I'm aware of the fact that many of the states now are talking about not cooperating with the federal government. What punitive measures might be expected from the federal government if the states assert their sovereignty in terms of how they're going to deal with this question?
Okay, I think we'll start there, and then we'll come back to these two questions.
This threat that the government's going to punish sanctuary cities by defunding them is not grounded legally. They cannot, I mean, actually, this is an interesting case where conservative Supreme Court ruled that the federal government cannot coerce states to implement federal laws, right? This was, I forget the name of the case. It had to do with the Brady gun law and registration of handguns. And the law required states to process background checks. And the conservatives sued, saying that the states can't be forced to implement federal laws, right? There's another Supreme Court, that was the Prince ruling. There's another court ruling more recently around the Affordable Care Act, where the court ruled that the federal government cannot punish you financially for something in an area that is not the reason for the punishment. So it could say remove immigration funds that go to New York City, which is actually very little, but it cannot take your housing money, right, or healthcare money, right? That's called putting a gun to your head, right? So there are strong precedents that would actually make it very difficult for them to deliver on that threat, right? Let me just answer something about how long. Well, if we do our work, we could get these people out in 2018. Well, before, I don't know. I mean, it's very strange what's going on down there. The whole thing could implode. Who knows, right? I mean, I don't think anybody could predict that outcome. But, I think we need the mass protest, but we also need to pay attention to the upcoming elections, both the Congress and also in the state legislatures, because the state legislatures will redraw the district lines in 2020. And that's been a lot of our problem, right, with the gerrymandering of districts to favor Republicans. So, it could be a turn in 2018. And I think even some of these terrible proposals or measures that the DHS has issued yesterday, it actually won't be that easy for them to do all of it. To hire 15,000 Immigration and Border Patrol officers would take them 4 years. First of all, it would cost them $4 billion, so they have to get that money from Congress. Even if they got that authorization, it would take them 4 years to hire and train that many people. The Border Patrol right now is not even at force level, right? They don't have enough people. but I think, as Adam said, a lot of this is to create fear, because now anybody is liable to be arrested and apprehended and deported anywhere in the interior of the country. That's a big change, right? But, you know, a lot of this, I think, is aimed at generating fear, because they don't have the wherewithal to actually deport 11 million people. And the point, I think, as Adam said, is they don't have to.
I would just add quickly to that, you know, there's also, in one of the executive orders, you know, a provision to fine and penalize, you know, generic term, but fine and penalize anyone who helps or aids or assists undocumented people, right? So speaking about activism and allies, you know, those are also categories of people that are being targeted, I think, by these larger campaigns. To speak very briefly to the question about whether it's helpful or it makes sense to think about the connection between immigration and economics, I think it kind of cuts both ways. And, you know, on the one hand, I think it's harmful because, from my perspective at least, you know, it tries to fit people into these really neat boxes, right? You're an economic migrant or you're a refugee. In so many cases, it's not quite that simple, right? People can't be categorized so neatly, as we all know if you've ever, you know, filled out a census form or you've done other things along those lines. And at the same time, it could be helpful perhaps functioning in this kind of binary system to say, well, I'm a worker. I want to come in and improve my situation, provide for my family. I'm obviously no threat. So I think it is a problematic way to see immigration, but perhaps within the dominant framework that exists, it could be helpful.
Maria Cristina, do you want to speak to the second question?
Yes, sure, on refugee policy. Historically, when you look at the grand sweep of refugee policy, the quotas have always been a function of the interests of the State Department and advocacy. So, and especially since 1980, since the White House is supposed to consult Congress, they hold a number of hearings. They have representatives from the State Department, from the Justice Department, Department of Homeland Security, and they listen to the concerns of all these different actors, and then they try to come up with what they think is a fair and humane quota. And it's parsed out to different regions of, you know, to different countries, different regions of the world. But which regions of the world get privileged has a lot to do with the State Department, but then also with advocacy. So as I said earlier, if you have advocates in Washington, D.C. who speak on your behalf, you are more likely to get one of those coveted refugee visas. Now, historically, you know, during the Cold War, the majority of refugees who came in were the most educated, highly skilled of their societies. And we benefited from their admission because in many cases they came in with intelligence that informed our military policies overseas. Since the end of, and as I said during my talk, anti-communism was the lens through which we interpreted who we would admit as a refugee. But since the end of the Cold War, many more people are potentially eligible for refugee status. And so what we're seeing in the post-Cold War era is greater diversity, not just in regions of the world, but in terms of the skills that they bring to the United States. And we're seeing more and more women and children coming in as refugees. Many of them do not have education or skills. They're coming in poorer. But they're not. But they're fleeing different kinds of persecution. They're fleeing, for example, trafficking. They might be fleeing gendered forms of persecution, like genital mutilation. There are many different grounds under which you might be considered for refugee status now in the post-Cold War era, which simply wasn't true during the Cold War era because of that anti-communist lens. Right.
Great. Up here.
Thank you all very much for your remarks. I have two questions, both of which are mostly directed toward Professor Ngai, but oh, it's not working? Oh, sorry. Oops. Okay. Bad musician. Okay. So I have two questions that are mainly aimed for Professor Ngai, but anyone else on the panel can address.
Quickly.
Can you speak a bit more?
Okay.
And we're.
Sorry.
Yeah.
So, first of all, related to Professor Goodman's recent remarks, have on the point of framing immigration in terms of economics rather than in terms of national security. Have there been any fundamental challenges to the logic of national security in the last few decades as the arbiter of who comes in as an immigrant, particularly given the roots of that policy in a very racist court decision that is predicated on an epistemological judgment of immigrants not being assimilable? Have there been any campaigns of legal or activist resistance against that core? Because that seems to me to be an effective point of vulnerability if the courts are willing to be as fundamentally reformist, so to be able to go there. My other question is based in some accounts of the San Francisco court decision that did review previous statements by the Trump administration and affiliates that framed this as explicitly a Muslim ban by other means. What are the roles of intent in adjudicating this case? Where does that sort of come in legally? And I understand that this is a panel of historians, but that seems to me to be an important point of vulnerability for activism, potentially.
All right, so for the first question, the short answer is no. The courts are not willing to entertain that. On the second point, just briefly, I think that it is, there is precedence to look, the whole question is, can you look behind the curtain, right? And the question of motivation, I think, is a legitimate one.
Could I not that really quick?
Well, we need to take just, I think, one more, and with apologies, we could go on, but we've taxed our guests. And
Okay, thank you, everyone. As some of you put in the timeline of immigration laws, a lot of these pro-immigration laws have responded to assimilation and American exceptionalism and these ideas of the American dream, starting from the 1965 Act to DACA and the DREAM Act. And now I think a lot of non-immigrant folks respond to this as well in a positive way, and we can see that in policy. But I guess being a little bit critical of those narratives, which we have started movements, immigrant movements, being critical of how these policies create desirable ones versus non-desirable ones. I guess my question is, with, I guess, the critical mentality of movements moving beyond this perception of national identity and inclusion, can this be reflected in policy?
You know, what was I going to say? I just had a moment. I had one of those moments. Oh, gosh.
If I could jump, I think what's really critically important about that question is that when we make certain bodies undesirable, this comes back also to Victoria's question, that we lose sight of the role of U.S. foreign policy and U.S. trade policies that have created systems of inequality and that have failed to respond to violent states and made bodies vulnerable to violence and to poverty globally. And so when we think about, which bodies are, and I think what was so excellent about the presentations today is that it speaks to the decisions by Congress or the decisions by the executive powers to limit the numbers of people that can come into the United States and to make bodies that try that through movement contest those numerical restrictions. It criminalizes them and labels them as undeserving. And so I think, when we see the executive order that targets parents specifically, or that makes space for dreamers, but not for their families, that we have to hold the government and legislators accountable for not implementing immigration reform, and for instead wanting to raise and charge taxpayers trillions of dollars for border enforcement. And so the sort of normalization of that, we have to actively push back against.
Okay, I'm back. So, I think this is a very difficult question, but actually maybe not so difficult. The leading edge to reform has always been a section of the population. So, yes, the Dreamers had a narrative of being the valedictorians, the innocent young people, but the Dreamers, I think, were the single group that changed American opinion about undocumented immigration and about the need for legalization. And the Dreamers themselves realized that they were not only fighting for themselves, but for their parents and for all undocumented, right? So if you think about even like Plessy v. Ferguson, right? Who was the plaintiff in that case? A man who was 7/8 white, okay? Test cases always choose the most respectable figure to make the best case they can, but it's on behalf of a larger population. So this is sometimes uncomfortable for us because we don't want to draw boundaries within our own communities, right? Right now, everybody's willing to say, yes, the criminals, they should be deported, right? Well, actually, you could make an argument that if you've committed a crime and you did your time, you're done, right? We don't punish people twice in this country, but we believe that immigrants who commit crimes, even if they're legally here, should be deported, right? And it's a whole crazy mess of what crimes are deportable. Like if you jump a turnstile in a subway station twice, you're deportable with no review by a judge. It's mandatory removal, right? So some of our attacks on criminal aliens are very unfair. They're very unfair. And yet, it's almost impossible politically to argue on behalf of criminals, right? I mean, we know this, okay? So I think there's a lot of work that we have to do, both in terms of educating ourselves and our communities, but also not insisting from a reform agenda point of view, not insisting on all or nothing, because change, unfortunately, doesn't always happen that way.
I just wanted to add a point. When you look at U.S. history, it's and this comes back to the question that you posed earlier. It's very easy to come away with this very romantic or idealized view of American history. I mean, we celebrate our immigrant stories through folk life festivals and parades and museums. But we've always had a very conflicted relationship with immigrants. And all throughout American history, our government has tried to engineer a particular population. At one time or another, we've tried to bar Chinese and Japanese and other Asian groups. We've tried to bar Southern and Eastern Europeans from coming, Mormons, Catholics, the poor, anarchists, communists, you name it. We've tried to engineer a particular population at different moments of our history, and this historical moment is part of that historical continuum. But all throughout American history, it's taken people of goodwill, of conscience, to resist. And the reasons why eventually the racist national origins quotas were lifted is because people of conscience and of goodwill. And as May said, it just takes a small group to create that tipping point to bring about a policy response. And so it's up to us at this historical moment to decide what kinds of steps we want to take in order to create the society that we want to live in.
Would you join me in thanking Monica and our panel? Thank you so much.